We have the opportunity to make a habit of empathy.
As members of the Senate Judiciary Committee, my colleagues and I have the opportunity to wrestle with some of the most important constitutional issues facing our country. The nomination of a new Supreme Court justice, itself an historic event, and the hearings that follow inevitably raise just such questions. And as you would expect, the nomination of Judge Sotomayor to replace Justice Souter has raised questions about the role of the Supreme Court, about judges generally, and about keeping faith with the Constitution. Inevitably, I guess, critics have unleashed an avalanche of innuendo and even falsehood meant to weaken the case for Judge Sotomayor's confirmation. Some have walked back from some of the worst charges that have been leveled, that she is a racist, for instance, but troubling undercurrents remain. These suggest that Judge Sotomayor's life experience is somehow unhelpful to the judgment she would bring to the Supreme Court, or that nominees are activists because they have, to quote President Obama, empathy. This merits a response, I believe, because it is harsh, narrow-minded, and ahistoric to contend that a rich life experience and natural empathy are at odds with the wise exercise of judicial discretion that is the long-standing tradition underlying the American system of law. First, as we all know, discretion is at the heart of the judicial role at all levels of the court system. I hardly need to remind a room full of lawyers that the common law traditions of the Anglo-American system stand on the exercise of judicial discretion, accumulated over generations of individual exercises of judgment and common sense and discretion, focused over time through due deference to precedent. It is the architecture of judge-made law we live with to this day. As a result of this heritage, our legal system bears the imprint of the experience and wisdom and judgment of generations of judges. As Justice Holmes famously explained, the life of the law has not been logic. It has been experience, the felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men. Right-wing critics of the administration have latched on to President Obama's description of good judgment as empathy. Even the ranking member of the Judiciary Committee, Senator Sessions, recently suggested that President Obama's use of the word empathy indicates a belief, and I quote him, that a judge should use his or her personal feelings about a particular group or issue to decide a case. I respectfully suggest that that is a bit of a stretch. The President looked for in his nominee and found in Judge Sotomayor the life experience necessary to understand how a court's legal determinations affect the everyday lives of everyday people. Do critics of Judge Sotomayor's nomination really object to this principle? Should we not prefer a nominee who has common sense, who can appreciate how American laws affect different citizens, and who can empathize with the various parties who come before the court, rich or poor, strong or weak? If reaching correct outcomes were as simple as plugging a few factors and elements into a computer, we wouldn't need 9 Supreme Court justices. Appellate court judges sit in panels of 3 or 4 or 5 or 7 or 9 as a reflection of the fact that a broad range of perspectives and experiences makes for better judgment. As Judge Sotomayor correctly explains, judges must not deny the differences resulting from experience and heritage, but should attempt, as the Supreme Court suggests, continuously to judge when those opinions, sympathies, and prejudices are appropriate. Not that they're never appropriate, but it's a matter of judgment when. Compare that rich and candid consideration of the interaction between experience and judicial judgment with the facile analogy favored by the Republicans that judges are umpires who do no more than call balls and strikes. Of course, that analogy is mistaken. First, lest we forget, Republican nominees themselves recognize that a broad life experience makes for better justice. Less than 4 years ago, Sam Alito, then a judge on the Third Circuit, explained that his personal background and experience enriched his judgment in legal cases. He said this: when a case comes before me involving, let's say, someone who's an immigrant, and we get an awful lot of immigration cases and naturalization cases, I can't help but think of my own ancestors, because it wasn't that long ago when they were in that position. And so it's my job to apply the law. It's not my job to change the law or to bend the law to achieve any result. But when I look at those cases, I have to say to myself, and I do say to myself, you know, this could be your grandfather. This could be your grandmother. They were not citizens at one time, and they were people who came to this country. I would also contend that Chief Justice Roberts himself, who raised the umpire metaphor at his own confirmation hearing, embodies the weakness of that analogy. Writing in the New Yorker, Jeffrey Toobin recently described a pronounced ideological predisposition in Chief Justice Roberts, and I quote, "In every major case since he became the nation's 17th Chief Justice, Roberts has sided with the prosecution over the defendant, the state over the condemned, the executive branch over the legislative, and the corporate defendant over the individual plaintiff." Every major case. Maybe this is a pure coincidence, and maybe it is a further coincidence to again quote Toobin that this record, quote, has served the interests and reflected the values of the contemporary Republican Party. But I will confess to you, I doubt it. I think that this record disproves the metaphor of the judge as neutral umpire. Why does this matter? It matters because denying the vital role of judicial discretion and judgment builds in a bias towards mechanistic judges who fail to understand how court decisions actually affect the lives of everyday people. Mechanistic judging, in turn, leads to judicial bias in favor of the prevailing power structure as an inevitable tendency. And the false denial of discretion's historic role establishes as a baseline norm against which variation is viewed as eccentricity a particular and actually rather narrow worldview. Is it really the case that white men who came to prominence through the Federalist Society have no predispositions? Should the judicial appointment and confirmation process anoint their views as the baseline or the norm? Consider some of the recent decisions of the Supreme Court. We had to step in after the infamous Ledbetter decision that mangled congressional intent, gutted important protections of Title VII, and reversed years of judicial practice. Justice Ginsburg observed in her telling dissent that the decision ignored the practical realities of the day-to-day experience of the workplace and the history and the nature of discrimination on basis of sex. As Justice Ginsburg noted, as a result of the lack of understanding and empathy with those in the workplace, the court, quote, ordered a cramped interpretation of Title VII, incompatible with the statute's broad remedial purpose. In conclusion, American courts bring justice to the American people in significant part because of the discretion we entrust to our judges and justices. Broad and diverse life experiences can make for better judgment and truer justice, and we should celebrate a nominee who would bring these qualities to the court. Indeed, is Judge Sotomayor's life experience as a wise Latina woman or President Obama's concern for judicial empathy really the issue? Or does that stated concern reveal more about the critics than about the judge and the president? Does it not perhaps reveal an impatience with any worldview that has not been groomed in corporate boards, scrubbed by the Federalist Society, cosseted by privilege and exclusion, and comforted by the status quo? Our world, I think, is bigger than that, and our Constitution must be sized to fit that larger world.